The civil fraud trial involving former president and 2024 Republican presidential candidate Donald Trump continues to unfold, with a major point of contention being the valuation of his Mar-a-Lago club in Florida. On Tuesday, October 10th, the Attorney General alleged that the club was significantly overvalued on Trump's financial statements. However, Trump firmly asserts that the property is worth $1.5 billion. This disagreement over the valuation of Mar-a-Lago took center stage just before a lunch break during the proceedings. In a crucial phase of the trial, Allen Weisselberg, the chief financial officer of the Trump Organization, faced intense questioning regarding the club's valuation. To support their case, the Attorney General's office presented evidence that aimed to shed light on Trump's financial dealings. One piece of evidence introduced was a clipping from the New York Post, which had a handwritten note on top. So, under this note, there was an email from Weisselberg to this guy Patrick Burney, who works for Trump. They were talking about selling another property in Palm Beach. Weisselberg said he gave Burney all this info to help him out, because he didn't know a lot of people in Florida. And get this, along with the email, there was an article about a Palm Beach estate being sold for $135 million. Plus, there were some handwritten notes. But here's the thing. Weisselberg denied that the notes were written by him. So, it got everyone wondering where they came from and if they were important to the case. But then, things got super interesting when someone showed Weisselberg a Wall Street Journal article with a sticky note that had his handwriting on it. The note said, "Patrick, hold on to this for next year's financial statements. Let's see how much it sells for." The admission carried a lot of weight because it suggested that Weisselberg and the Trump Organization understood the importance of actual selling prices and property valuations, rather than just asking prices. This revelation raised doubts about how Trump's properties, including his Mar-a-Lago club, had been valued. It hinted that the valuation process used, which relied on asking prices and inaccurate square footage measurements, was seriously flawed. This new information added fuel to the debate about the accuracy and transparency of Trump's financial statements, which is a major part of the legal battle. The conflicting valuations of the Mar-a-Lago club highlighted the need to uncover the truth behind these financial documents and figure out if they were purposely inflated for personal gain. As the trial trudged on after everyone's food coma from lunch, the spotlight continued to shine brightly on Trump's financial shenanigans and the questionable involvement of people like Allen Weisselberg. This trial has the potential to shake things up, not just for Trump, but for the entire legal world. When it comes to money matters, brace yourselves, folks. Special counsel Jack Smith decided to take things up a notch and filed a motion to protect potential jurors in Trump's election subversion case. And former U.S. Army prosecutor Glenn Kirshner had the perfect quip for it. He basically said, "Smith didn't just take off the gloves, oh no. He boxed them up, sealed the box, and sent them off to a place far, far away." Now that's what I call some serious moves. Kirshner spilled the tea on his latest episode of the Justice Matters podcast, and it's definitely worth a listen. Smith advised Chutkan to speed up the jury selection procedure, using a questionnaire for possible jurors, to forbid the release of their personal information, and to forbid attorneys from making direct contact with the jurors. The Republican frontrunner for 2024 made reference to the former president's social media attack on a court official during his civil fraud trial in New York, which led the judge to impose a gag order on him. According to Kirshner, Trump's attorneys have resisted the motion. He said, "If Donald Trump has proven anything, it's that he's ready to put witnesses, jurors, prosecutors, judges, and their respective families in risk." And you won't believe what special counsel Jack Smith is suggesting in the Donald Trump election subversion case. He's basically saying, "Hey judge, let's make sure these potential jurors don't get harassed or have their personal details leaked." Can you imagine? They want to start screening jurors early and keep their identities, but it's also like saying, "Hey, attorneys, we trust you not to go snooping around. Let's hope these measures actually work and protect those involved in the trial." The prosecutors argue that due to the sensitive nature of this case, with heightened public interest and the defendant's history of using social media to attack others, certain restrictions should be imposed on the party's ability to research potential jurors and use juror research. They specifically mention an incident that occurred last week in Trump's civil fraud trial, where he openly criticized the state attorneys and judge, and targeted the judge's top clerk on social media. As a result, the judge issued a limited gag order on Trump, preventing him from commenting on court staff. It is important to note that the judge is currently considering Smith's motion for a broader gag order in the Washington, D.C. case. Smith is requesting a court order prohibiting Trump from intimidating or insulting any possible witnesses in the federal trial, which will start on March 4th. The request for a gag order will be heard by Chutkan on October 16th. In other cases, prosecutors extensively relied on Trump's remarks to support their case. They also pointed out that Chutkan and the grand jurors who charged Trump in Fulton County, Georgia, had received threats from his fans. A proposal made by Smith's team includes forbidding any form of direct communication between the lawyers and prospective jurors, including friending or following them on social media. It would be okay to do open-source research, as long as it doesn't become vexatious or harassing. Prosecutors contend that any personally identifiable information from this study should not be made available to the public. Such a precaution is not only necessary to ensure that all parties handle sensitive juror information responsibly, but also so that the court can assure prospective and seated jurors in this case that no party will improperly use their names or other identifying information. Gaston and Wyndham wrote in their opinion. Prosecutors also suggested that the court take into account a strategy employed in other high-profile trials, having jurors enter and exit the courtroom in a discreet way, rather than through the main doors. The Smith team left the possibility of pursuing further safety precautions open for the future. The prosecutors claim that at least some of the actions Smith's team is requesting are opposed by Trump's attorneys. Smith's team is not advocating the drastic measure a federal judge in New York took earlier this year in a civil case involving Trump, having potential jurors remain completely anonymous to both the defense and prosecution. While the prosecution suggested a number of measures aimed at protecting the jurors in the case, Smith's team is. But it's also like saying, "Hey, attorneys, we trust you not to go snooping around."